From supplementary cause list, item number 1.
Made, please, also. Lordship, this is a contempt of the order of the arbitral tribunal, my lord. Kind see the order of the arbitral tribunal, my lord, dated 19/2/2024 at page 9.
Before my learned friend begins, I must point out before your lordships how this matter has come to be before your lordships.
I'll place all the facts. Let me place my case. I'll place everything.
Let my learned friend place it, my lords. I have no difficulty in it. There's only one issue, my lords. I would urge your lordships to first hear us on the issue of maintainability before, my lords, your lordships proceed on the merits.
Before we proceed further,
yes, my lord.
See, a query of this court would be, why was this matter placed before division bench?
My lords,
yes, I'll place that aspect, my lord. I'm the applicant here, Mr. Paul.
There's no question of applicant here, my lords. That's what I'm trying to point out. Because what had happened is, my lords, there is an order passed by the tribunal.
Your audio is not so clear, Mr. Kumar.
Oh, sorry, my lord. Am I clear now? The court, my voice can be increased, my lord, by the court master. Am I clear, my lord? Kindly see how it has traveled. That is what I'm trying to answer, my lord. Kindly see page 9. This is the order of this the arbitral tribunal dated 19th February 2024, my lord, page 9.
Yes.
This is the application which we moved before the arbitral tribunal. My lord, I will read this order, then I will place sequence of event, how it has reached before your lordship. And an application is filed by the respondent number 1. Page 9, my lord, page 9.
Yes, please.
Paragraph 1. An application is filed by respondent number 1, State of Meghalaya, praying for initiating contempt proceeding against the claimant for non-compliance and disobedience of the order of 8th November 2023, read with order dated 10th November 2023, passed by this tribunal. After constitution of this tribunal, an application was filed by respondent number 1, that is statement, under section 17 of Arbitration and Conciliation Act, praying for interim direction, including securing payment of the lease rental amount which is not paid by claimant, despite being in admitted possession of the subject property. When the said application was filed, notice was issued to the claimant of the said application. Claimant filed a reply to the said application. Thereafter, application was taken up for hearing on 8 November 2023. When the counsel for both the parties were heard, on conclusion thereof, an order was passed on the same day, that is on 8 November 2023, whereby the application was allowed and detailed order was passed which included the following paragraph. However, since it is an admitted position that claimant is in possession of the subject premise and there is a huge claim of non-payment of such dues towards rent for long period, we deem it appropriate to direct the claimant to deposit and pay the entire admitted and contractually fixed rent of the subject premises to the respondent number 1 effective 7th June 2022 to 31st October 2023, along with government taxes and dues within 6 weeks from today, that is on or before 20th December 2023, for which a receipt shall be granted by respondent. So far as period from 1st October 2016 to 6th October 2020 is concerned, and which is subject matter of counterclaim, claimant shall furnish a bank guarantee of an amount of 2 crores in favor of respondent number 1, which shall be made valid and operative till the disposal of arbitration proceeding. We consider this amount of rupees 2 crores from which the bank guarantee is to be furnished is reasonable and equitable. It is only 50% of the claimed amount of the respondent number 1. In our opinion, this order would protect the interest of the party and equity of both the parties. Said order was modified to an extent by issuing a subsequent order dated 10th November 20. Despite the aforesaid order and direction contained therein, claimant has failed to abide by and comply with the said order and direction. This is in spite of the fact that para 4 of the said order, it was specifically mentioned that the compliance of this direction should be made by claimant on or before 20th December 2023. Since the claimant has failed to comply with the aforesaid direction, the respondent number 1 has filed the present application, praying for taking action against claimant in terms of prayer in application for violating and disobedience of the order of this tribunal. We have heard the learned counsel appearing for the parties on this application today. Counsel appearing for the claimant on instruction received from Managing Director of the claimant company, Mevin T. Marbangyan, who is personally present in the proceeding, today stated that claimant is unable to comply with the aforesaid direction of this tribunal for some reason. Our considered opinion, the stand taken by the claimant cannot be appreciated. We feel that non-compliance of such interim order passed by the arbitral tribunal, including direction to pay lease rental amount as due and payable despite being in admitted position of the project, is in total defiance and disobedience of the order of this tribunal. The effect of this order on the arbitral proceeding will be considered at a later stage, but at this stage, we are of the considered opinion that proceeding under the Contempt of Court Act is required to be drawn up against the company and the person responsible for running of the claimant company. Since the tribunal does not possess the power of jurisdiction to take action under Contempt of Court Act, yet we feel that matters would require a strict action, their contempt proceeding to be taken by the Honorable High Court of Meghalaya. We therefore refer the matter to the registry of the Honorable High Court of Meghalaya for placing the matter before the Honorable Chief Justice of Honorable High Court of Meghalaya to pass necessary order for doing the needful in the matter. The matter shall be placed before the registry with this order along with all the relevant documents by the counsel appearing for the parties. We may, however, make it clear that this order would not in any manner constitute as fetter on the rights of respondent number one to make all other course of action as may be available to the respondent for such compliance in accordance with law. After this order, my lord, the contempt was filed by the state of Meghalaya, my lord, and then your lordship will see first order is of 31st May 2024 by learned single judge, my lord. Kindly see the order sheet now, my lord. And those orders, my lord, one after the other, your lordship will find. First order is 11. There are series of the order, my lord.
Yes, yes.
And first order is started, my lord, from these orders, your lordship will find one after the other.
Just point out the relevant order. These are just.
Yes, my lord. Notices were issued, my lord. Notices were issued, my lord. After issuance of the notices, my lord, they took about 6 to 7 days to file reply. Ultimately, matter was heard on 4 July 2024. Kindly see, my lord, order of 4 July 2024. But I just wanted to show the conduct, my lord. Conduct is also important because their disobedience is there by them before the
hearing us on maintainability.
That is immaterial as of
Lordships are hearing us on maintainability.
Please continue.
Yes, my lord. 4th July 2024 order, my lord. Kindly see. Heard learned counsel by the parties. Mr. K. Paul, learned senior counsel assisted by Ms. So-and-so, De Cruz, learned counsel for the respondent on the challenge to maintainability of the instant contempt petition has drawn attention to the court order of 19 February 20 passed by the learned arbitral tribunal arbitral proceeding. It is submitted by the learned senior counsel. The petitioner was not at liberty to file present contempt petition. Inasmuch as the learned arbitral tribunal has referred the matter to registry to be placed before the Honorable Chief Justice, though the objection has been raised by learned Advocate General in view of the order passed by learned arbitral tribunal, place the matter before Honorable Chief Justice, my lord. Now kindly see the rules of High Court rules in this regard, my lord. Contempt of courts, rule, my lord. Rule 6, my lord. The rule starts, my lord. Contempt of court, High Court of Meghalaya, rules 2013.
Yes.
And kindly see rule 6, my lord.
Yes.
Now, rule 6, my lord, every petition, motion or reference in relation to criminal contempt shall, unless the Chief Justice direct, it is to be heard by larger bench, be led for a motion of hearing before a division bench, my lord. That is for criminal. 2, every petition, motion or reference in relation to civil contempt shall, unless directed otherwise by the Chief Justice, be laid before single judge. So, civil contempt, my lord, unless directed otherwise by the Chief Justice, be laid before single judge. Now, my learned friend raised the objection saying that the order has been passed by arbitral tribunal to be placed before the Honorable Chief Justice. Now, Honorable Chief Justice, my lord, of Meghalaya has place the matter, every petition under 6.2 before your lordship, before petition, motion or reference in relation to civil contempt shall, unless directed otherwise by the Chief Justice, be laid before a single judge. So the Honorable Division Bench, Honorable Chief Justice, my lord, has placed the civil contempt in terms of Rule 6.2 before your lordship. And the requirement of law is, my lord, now 3, kindly see, every notice issued by the Honorable High Court shall be in the form appended to these rules and shall be accompanied by a copy of motion, petition or reference as the case may be, together with the copies of the affidavit, if any. 4. The notice shall bear the date and seal of the High Court and shall be issued under the signature of Registrar General. 5. Notice of every proceeding under this Act shall be served personally on the person charged unless the High Court, for reasons to be recorded, directs otherwise. 6. My lord, High Court may, if satisfied that person is charged is absconding or likely to abscond and is keeping or likely to keep out of avoid the service of notice, order the issue of warrant of his arrest in this case of criminal contempt and may, in lieu of, in addition to attachment of properties, my lord. 7. My lord, wherever the High Court issues a notice, it may, if it sees reason so as to dispense with the personal attendance, my lord. Now, kindly see the form, my lord, form of civil contempt, Rule 9, my lord. Rule 9, my lord, civil contempts. Type it.
Page.
In case of civil contempts, Rule 9, my lord.
Page 4, Lordship.
Yes.
Rule 9, my lord. Rule 9, my lord. In case of civil contempt other than contempt referred to Section 14, High Court may take action on its own motion or a petition presented by aggrieved. Kindly, on a petition presented by party aggrieved, or in the case of any civil contempt of subordinate court on reference made it by that court, my lord. Tribunal is subordinate, my lord, and I am also covered by 9b, my lord. 10, my lord. In a case of civil contempt, other than contempt referred in Section 14, person charged may file his affidavit by way of reply to charge and shall serve a copy thereof petitioner or his counsel at least 7 days before the hearing. No further written affidavit or document shall be fixed except with the leave of the court. So the requirement, in my humble submission, according to me, my lord,
we have not reached the stage of 10.
Your lordship, learned single judge has already issued notice on contempt, and notices and reply has already been filed under 10.2, my lord. Reply has already been filed, my lord. The notice has gone by the learned single judge of this court, and the learned single judge is competent under the Rule 6.2, my lord, to issue contempt notice, and that has been done. Now the issue was the raise. I have shown your lordship's order, and kindly see the form, my lord. Kindly see the form. Form at 6. At form appended to Rule 6.3, my lord, which is there at page 7, my page 7, after Rule 20, my lord.
Notice that we've got from court.
Notice.
Yes, my lord. Notice proceeding under Contempt of Court Act 1971. Whereas from the material laid before this court, it has been made to appear that you are guilty of contempt, punishable under Section 12 of Contempt of Court Act. Proceeding the matter will be laid before the court for determination of charge on so and so date. You are hereby directed to attend this office in person or through counsel to answer the charge and to file an affidavit at least 7 days before the said date in support of your defense, if any. Given under my hand the seal of this court, my lord. Now, this is the background in which the matter has traveled to your lordship. Kindly, notices have already been issued by this honorable court by learned single judge, my lord, and I will place all these orders. They have been seeking time and again, my lord. They have been seeking time for last 6 months to file reply. Ultimately, they have filed reply. In reply, the stand is that this contempt petition is not maintainable on the ground that there is no violation there is no violation, and the matter is pending before the honorable High Court before the Arbitral Tribunal. Kindly
Yes,
see the order.
Mr. Before you proceed, Mr. Paul, what do you have to say?
It's 3 things. I'm lucky, my lord, my learned friend
I
has
finished,
taken
my
your
lord.
lordships. I'll just take your lordships to Rule 9. Rule 9, your lordships have seen, Mills, of the High Court rules.
Yes.
9C would be relevant for our purposes, Mills, because the order which they say is allegedly violated is an order passed by the learned arbitral tribunal. So, in case of Rule 9, Mills, where Rule 9 is attracted, your lordships will see that the rules are very specific that in case of any civil contempt of a subordinate court on reference made to it by that court. Now, the tribunal was conscious of this fact, Mills, which is why I'll take your lordships back to the orders passed by the tribunal. And that is the reason why, Mills, this matter was referred by the learned single judge to the Honorable the Chief Justice. If I may take your lordships to the orders at page 11, Mills, paragraph 5. If my lords have it, Mills, last line of paragraph 5, Mills. We therefore refer the matter to the registry of the Honorable High Court of Meghalaya for placing the matter before the Honorable the Chief Justice of the Honorable High Court of Meghalaya to pass necessary orders or for doing the needful in the matter. So what happened, my lords? There is a reference made by the learned tribunal before Honorable the Chief Justice. What the state of Meghalaya does is, my lords, it decides to come before your lordships by way of filing a separate contempt application under section 12. Your lordships would find that at page 1 of this contempt application. If your lordships kindly see the cause title, my lords. Your lordships have it, my lords. It says it is an application under section 12 of the Contempt of Courts Act.
Now, article
215, my lords. 215 would be the original source of power, my lords.
Definitely.
My
That's
lords.
contempt of High Court.
Lordships. Now, if I may just take your lordships to section 12 of the Contempt of Courts Act. If my lords kindly have the Contempt of Courts Act. My lords have it. Talks about punishment for contempt, my lords.
Yes.
Well, it's save as otherwise expressly provided under the Act or in any other law, or contempt of court may be punished with simple imprisonment for a term which may extend to 6 months, or with fine which may extend up to 2,000 rupees, or with both, provided that the accused may be discharged on the punishment awarded, may be remitted on apology being made to the satisfaction of the court. Now, the question here, Malaj, which Malaj, I ask myself is that once the tribunal has referred the matter to the registry of this honorable court, Malaj, whether a separate application on behalf of the petitioners before your lordships was maintainable in law. In my humble submission, my lords, it would be in the negative because there cannot be two parallel proceedings on the same issue. And this is the same issue, my lords, which was argued before the learned single judge. And my lords, the learned single judge had placed the matter before Honorable the Chief Justice, and I've seen the noting of Honorable the Chief Justice, my lords, who has now placed the matter before your lordships for adjudication.
Where's the notice?
Well, it is there, if your lordships kindly. Court master, if you kindly
This is not a
please.
criminal contempt.
It's not a criminal contempt, my lords.
So normally it should not be in division.
Ideally, it should not be before a division bench, but because of
Since it
this,
has come, so
because it's specific, my lords, the order is very specific. So it is therefore, my lords, what I was trying to point out initially, it is therefore it has come before a division bench before your lordships.
Milord, this issue is
think,
covered by the judgment of this. Milord, Your Lordship has heard my friend.
Now,
Your
now
Lordship,
I'm not done. I'm
hear
not
me
done.
on the
I'm not
then
done. Let me
last
raise
point
the
will
issue
not
of
finish.
maintainability first, Milords. My
Let me
learned friend can
my Milord.
respond.
Let me take
see,
the-
Mr. Kumar, I believe we are
Yes.
still in the stage of looking to the form and format
My lords,
of how this how the proceedings
have come before your lordships.
can be taken up by this court.
My lords,
Yes, my lord. Kindly see on this issue. I will assist, my lord. Let me give me
my lords, may I
opportunity
first
to assist.
finish?
Let us hear Mr.
Because I have not. Lordship has I'll in
Let us
between asked some questions to my friend, but I have not finished my argument, my
see,
lord. Please
basically
hear me first.
see Mr. Kumar, basically your reliance would be only on Rule 6.2.
I have not finished, my lord. Your lordship permit me to argue my case, then only your lordship can come to conclusion that I am
My
relying on
lords,
one part only.
your lordships are correct,
Hear
my
me,
lords.
and then
What
thereafter
what
hear
I'm
my
humbly
friend.
what I'm humbly submitting before your
One at a
lordships is
time.
Please
your
hear
lordships
me,
have
lord.
now understood how the matter has come before your lordships.
And
Power
let
under
me
6.2 has
give
been
us
exercised by Honorable the Chief
lordship,
Justice, my lords.
allow me to
Matters
give
come
a
before.
sentence.
See,
Kindly see. Yes, my lord.
Mr. Kumar, on top of the fact that we can see you're excited, but the point is
No, I'm
your
not.
your voice
Sorry.
is not maybe
I'm why
your
I have to.
is
I'm
your
really sorry.
audio is not so audible.
No, I'm sorry, my lord.
It's
What
not
has
so,
happened, my lord? Because
there's
in
some
every
break.
matter what I see, my lord, in every matter what I see, when I start my argument, my friend will stand up and he will not allow, and
No,
in
we
between
will
some
hear
questions
you.
will
We'll
be
hear
put.
you.
I have to, so please hear me, and then thereafter your lordship find that
My lords, if
my
there is
friend
a
is
challenge to maintainability, I
I
have to
will
open.
Let us see. Let us hear. Since he wants to,
in
No, but I am only submitting, my lords. If there's
he
a
says that
challenge to maintainability, I have to say, my lords, how I am challenging the maintainability. My learned friend will respond.
he says he has not complete his piece. So let him see. But
My lords,
Mr.
I
Kumar,
bow down.
can you please check your audio?
Yes, your lordship. I'm sorry, my lord. My audio is not. Rule 6, your lordship. Kindly see. Rule 6. Kindly see the contempt of court.
I think we have
The High
gone.
Court rule.
We have gone through
Rule
that.
6. Your lordship's query has fallen. How this matter has travelled not before your lordship. That is, I'm trying to answer that, my lord. My endeavor would be to answer that question, my lord. Rule 6.2, my lord. Precise. Rule 6.2, my lord. Now, the Rule 6.2 says, my lord, every petition, motion or reference in relation to civil contempt shall, unless directed otherwise by the Chief Justice, be laid before a single judge. In ordinary course, the matter will be before the learned single judge, my lord. But the rule also confers, in my humble submission, power on the Honorable Chief Justice to place it otherwise also, place it before division bench also, my lord. That is my first submission, my lord. Rules in terms of Rule
Exactly.
6.2, Honorable Chief Justice has been conferred power to place it before division bench, my lord. So that is how the matter has, in my humble submission, has travelled before your lordship. Now, my friend has pointed out the order passed by the arbitral tribunal, my lord. Kindly see the order, one paragraph of the order of the arbitral tribunal, which is at page 11, my lord. Kindly see page 11 and paragraph 5, my lord. Paragraph 5, my lord. Since the tribunal does not possess the power and jurisdiction to take action under the Contempt of Court Act, yet we feel this matter would require a strict action, and therefore the contempt proceeding be taken up by the Honorable High Court of Meghalaya. We therefore refer the matter to the registry of the Honorable High Court of Meghalaya for placing the matter before the Honorable Chief Justice of the Honorable High Court of Meghalaya to pass necessary orders for doing the needful in the matter. The matter shall be placed before the registry with the order, along with the other relevant documents by the counsel appearing for respond number 1. This is, my lord, we may, however, make it clear, this order would not in any manner construed as a fetter
Anyway,
on the right of...
that is beside the
So
point.
this is a mode through which, my lord, I have
Exactly.
placed before this honorable court.
Exactly. Now,
And this honorable court...
Mr. Kumar,
Yes, my lord.
at this point of time, when this
Yes,
order
my
was
lord.
passed,
Yes, my
what
lord.
steps was taken, whether the matter was placed before the Chief Justice or not?
Yes, my lord. Kindly see this line. We therefore refer the matter to
Yes.
registry of the Honorable High
placed.
Court.
So where
Now,
is-
kindly see
where is the
my
reference?
petition.
Not placed. my lord.
Yes, Lord. Yes, I'm just coming, my lord. Kindly
Not
see
placed.
my
What happened?
Just a moment.
and kindly see, my lord, the application, my application at page 1. Page 1, my
See,
lord.
Mr. Kumar, who is to place the matter? Is it you?
This is the
Is it you or the tribunal?
the tribunal has, if your lordship
see,
will
the tribunal
third
would-
line, second line of
See,
second line of page 12, your lordship will see the answer is there in the page 12. my lord.
yes.
Page 12, it says the matter shall be placed before the registry with the order along with all other relevant document by the council appearing for the respond number 1, my lord.
Exactly.
Very well.
So who does the
Yes, so
placement?
I have
Who does
so I have-
who does the placement?
I have done the placement, my lord. I am the counsel for respond number 1 in this case. And your lordship has to see, kindly see,
See,
how do I place
see,
before there is a process laid down.
See, Mr. Kumar.
Now the
See,
question
Mr.
which is before your
see,
lordship.
Mr.
that
Mr.
it
Mi- see, Mr. Kumar. Read the.
Yes, my lord.
See, you interpret this order here.
Yes.
It says
Yes, my lord.
matter to be placed before the Honorable Chief Justice.
Yes, my lord.
Honorable Chief Justice. It does not say the court.
Yes.
So registry is there
Yes,
to
my lord.
place the matter before the Chief Justice. So we are on at that. You see, on that issue, whether
Yes, my lord.
at the relevant point of time, this order was placed before the Chief Justice. If it was
Yes, my
placed, then it would
Yes,
entail
my lord.
a necessary order by the Chief Justice. Thereafter,
Yes, my lord. Yes, my lord.
the proceedings would commence.
Yes, my
You would
lord.
be
Yes, my
allowed
lord.
to file your petition or otherwise, and the response
Yes,
would
my
be
lord.
there.
I'm not.
But
let
it
me
appears
answer. Let me
it appears
answer the
nothing
query.
is there on record.
No, my lord, let me answer the query which has fallen from your lordship. Your lordship is saying, what your lordship is saying, that the matter before the registry has to be placed by way of some application or some form, my lord, because I have to do in accordance with some form, my lord.
Has to be a reference.
What your lordship is saying, that there is no contempt if it is not placed in terms of the order of the tribunal, my lord. If I have construed the your lordship's observation correctly, my lord. What your lordship is saying, contempt will be made out only when it is placed before the honorable Chief Justice by way of some letter or some document,
It
and
has-
then
it-
there
it
is
has
a
to be-
order
it
by the
has-
honorable Chief Justice.
It has to be by way of a reference.
No, this is not by, this is reference, my lord. Kindly see again the order, because your lordships, in my humble submission, has to construe the order in the manner in which, if your lordship will see, if the reference is what, my lord, the registration of the, I have got remedy in both ways. I have a remedy, my lord, under, if your lordship will see last line of the order also, tribunal's order also. Kindly see page 12, last 3 line also. We may, however, make it clear that this order would not be in any manner construed as a fetter on the right of respond number to take all other course of action that may be available to respond number 1 for such non-compliance of the order, my lord. So if there is a non-compliance of the order, I have also remedy to approach your lordship, and that your law is well settled, my lord. Kindly see 2017-16 SCC 119, my lord, judgment of the Honorable Supreme Court on this issue. My learned colleague will place that judgment, my lord. 2017, 16 SCC 119, my lord. Paragraph 1, my lord. Facts are there because facts. The leave granted, my lord.
Yes.
The leave granted, the present appeal arises from the judgment of Bombay High Court dated 27th October 2015, in which the High Court has construed the section 27(5) of Arbitration and Conciliation Act 1996 in a somewhat restrictive manner. Facts necessary to appreciate the point involved in this appeal are that on 7th October 2010, the sole arbitrator appointed by parties passed an interim order under section 17 of the said act, in which it was mentioned that no further facts were to be disposed of without the leave of arbitral tribunal. In the breach of this order, it is alleged that on 14/10/2010, the respondent in fact transferred 5 such flats. By order dated 23rd March 2012, it was held by learned arbitrator that order of 7/10/2010 had in fact been breached by the respondent, and certain other interim directions were made by the aforesaid order. Ultimately, by an order dated 5th May 2014, the learned arbitrator referred the aforesaid contempt of the order of 710 to the High Court to pass necessary order under 27(5) of the Act. In the judgment in the appeal, under the appeal, High Court held in paragraph 29, paragraph 2, Milord, in view of the discussion, section 27(5) of the Arbitration and Conciliation Act 1996 does not empower the tribunal to make representation to the court for contempt if the orders, including the interim orders passed by arbitrator, except in respect of taking evidence, are violated by party. Contempt petition, being the representation made by the tribunal, is beyond the period of limitation, is not maintainable in law. Moreover, final award of rupees 8 crore is granted in favor of the petitioner by the arbitrator. We have heard the learned counsel for the parties. Sri Marpalle, learned senior counsel appearing on behalf of the appellant, has argued that section 9 and 17 being alternative remedies available to the parties before the tribunal. If orders made under section 17 were unenforceable, they would mere ropes of sand, as a result of which provisions would be rendered OTOs. He also argued that section 27 of the Act does not leave any doubt as to the scope and ambit of the court's power to punish the contempt of order made by arbitral tribunal. He relied upon Delhi High Court judgment and a judgment delivered by this court in Maruti Udyog versus Maninder Singh Mehta. On the other hand, Mr. Sri Rana Mukherjee, learned senior counsel appearing on behalf of the respondent, supported the High Court judgment. However, he fairly states that before us, he does not support High Court judgment on the aspect of limitation. According to him, marginal note of section 27 makes it clear that section 27(5) would only apply to assistance in taking evidence and not to any other contempt that may be committed. According to him, this lacuna in law has now been filled pursuant to the 24th law report, and which he has referred to and relied upon after section 17(2) has been inserted under 2015 Act. Having heard the learned counsel of the parties, we first set out the relevant statutory provisions, my lord. Kindly skip those provisions, my lord, and kindly come to page 123, my lord, section 27, my lord. At page 123, section 27 is quoted, my lord, and kindly see 27(5), my lord. Persons failing to attend in accordance with such process, or making any other default, or refusing to give their evidence, or guilty of any contempt to arbitral proceeding during the conduct of arbitral proceeding, shall be subject to like disadvantage, penalties, and punishment by order of the court and representation of the arbitral tribunal, as they would incur for like offence in suit tried before the court. My lord, 27(5) is the main section. Now 6, my lord. If section 26, if section 27(5) is read literally, there is no difficulty in accepting the plea of learned senior counsel to appellant, because persons failing to attend in accordance with court process fall under the separate category from any other default. Further, the section is not confined to a person being guilty of contempt only when failing to attend in accordance with such process. Section specifically states that person guilty of any contempt to the arbitral tribunal during the conduct of arbitral proceeding is within its ken. The aforesaid language is in fact in consonance with the chapter heading chapter conduct of arbitral proceeding. Further, it is well settled that a marginal note can be used as an internal aid to interpretation of statute only in order to show what is the general drift of the section. It may also be resorted to when plain meaning of the section is not clear. In the present case, we must go by plain meaning of subsection 5. This being the case, we find it difficult to appreciate the reasoning of High Court. Also, in consonance with modern rule of interpretation of the entire object of providing that a party may approach the arbitral tribunal instead of court for interim relief, it would be stultified if interim orders passed by such arbitral tribunal are toothless. It is to give teeth to such orders, and express provision is made under section 27(5) of the Act, my lord. And last paragraph, my lord, paragraph 10, my lord, of this judgment, my lord. Accordingly, we allow the appeal and set aside the judgment of the Bombay High Court. The matter is remanded to decide the alleged contempt of the fact. It would be open to the respondent to argue before the High Court, since on the facts no contempt is made now. So my case, my lord, is before your lordship is twofold, my lord. One, that there is an order of the arbitral tribunal directing the petitioner to comply with this order. That order was not complied. We moved the arbitral tribunal for liberty to approach the Honorable High Court. The tribunal has, in the penultimate paragraph, has passed the direction that the reference is also made, and liberty was also given to me to approach this honorable court. My lord, now the question which my friend is raising before your lordship is that the mode and manner of reference before your lordship, therefore, and what he says that if there is a mode and manner of reference is not correct, no contempt is made up. That is what he is trying to say. In
No,
my humble submission,
I
my
don't
lord.
think we have proceeded that far.
So, my lord, kindly, whatever your lordship's order will be there, I'm bound by the order. But my submission is
We are,
twofold.
you see, Mr. Kumar, we are not saying you don't have a case. That would be considered in due course. But
May not the
how
due course will be
the see now we are
you allow your
see now we are concerned
whether your
now we are concerned with how the
contempt-
see Mr. Kumar, we are concerned with how the proceedings are to be initiated.
yes, my lord,
If
your lordship will see first order
they
of
should be in the
learned single
proper
judge.
form and format.
Yes, my lord, kindly see first order of learned single judge issuing notice on the contempt, my lord. Kindly see the first
That-
order of the learned single
At
judge.
that point of time, these
With
facts
due
were not
respect, I think that itself is not proper. Anyway,
Your lordship will
that's
your lordship may say that the contempt is not proper.
Subsequently,
Then
the
I will
learned
have
single
remedy.
judge clarifies this
Because
position.
person who is in possession and who is in breach of the order of the arbitral tribunal, section 17 order is nullified
Yes.
by saying that look, this is not a proper form. Then he raised that because he took 6 days to file reply.
In
After
any
6
case,
days, he says
yes,
that it's
I
not a
think-
proper form. Then thereafter, it is matter is placed before the Honorable Chief Justice under Rule 6.2
Yes,
in
see,
terms of
Mr.
reference, and the Honorable Chief Justice has placed it
We
before
have-
division bench.
we have-
Still, it is not in form. I don't know what
we
is
have
in
understood.
proper
We have
form.
understood your submission. We have understood your submission.
And only,
I think Mr. Paul.
only,
Yes.
and my anguish is only because if somebody is violating the order with
That is- that
impunity,
is-
my lord,
I said we are not-
and
we
he cannot be allowed to walk away scot-free
We
when the
have-
Supreme Court judgment is in my favor, law is in
See,
my favor,
Mr.
and
Kumar,
he is.
I said we have not traveled that far. Let us
In fact, reply has already been filed, my lord.
let us take one step at a time. See, Mr. Paul,
My lords.
from what I could understand, I may be wrong, but we are on technicalities here.
At the moment, yes, my lords.
We are not on, we are not
We've
addressing.
not reached, your
we are
lordships are not
addressing-
examining the merits
we
of
are
the
not
matter.
addressing the core issue.
Lordships,
So we are on technicalities.
if I may,
And
my lords,
even if there are irregularities,
my lords.
that should not come in the way of,
In contempt jurisdiction, my lords, in my humble submission, it does. The law is settled, my lords, that it has to be the absolute spirit and letter of the Contempt of Courts Act and the various enactments thereafter has to be followed to the teeth, my lords. Otherwise, it vitiates the entire proceedings, which is why your lordships are hearing us on this technical aspect. Lordships, two things which have already your lordships, it has fallen from your lordships also. In the order of the learned tribunal, my lords, there is the expression used by the tribunal is we refer the matter to the registry. Once there is a referral, my lords, it has to be construed as a reference to this honorable court. Now, once it is a reference, my lords, the secretariat of the tribunal would have to make a reference before Honorable the Chief Justice, my lords. In that event, a matter where your lordships would then, my lords, probably deal with the matter under Section 10 of the Contempt of Courts Act, not under Section 14, as is sought to be now made before your lordships. That is the first aspect, which is why, my lords, the last order of the learned single judge, if your lordships kindly have a look at, your lordships have read the order 4/7/2024, by which the matter was placed before Honorable the Chief Justice, my lords, may kindly have a look at it.
yes.
When this aspect was brought to the notice of the learned single judge, my lords, this order came to be passed. Mr. Sonso, learned counsel for the respondents on the challenge of the maintainability of the instant contempt application has drawn the attention of this honorable court to the order dated 19/2/2024 passed by the learned arbitral tribunal and arbitral proceeding number so-and-so. It is submitted by the learned senior counsel that the petitioner was not at liberty to file the present contempt application inasmuch as the learned arbitral tribunal had referred the matter to the registry to be placed before Honorable the Chief Justice. Though objections have been raised by the so-and-so, in view of the order passed by the learned arbitral tribunal, place the matter before the Chief Justice. So, my lords, once there is a reference by the tribunal, my lords, it is not open to us to have, there cannot be two contempt proceedings in respect of the same thing. They exhausted their remedy by filing a Section 27 application before the learned tribunal, my lords. Tribunal says, refer the matter to the High Court, place it before the Honorable the Chief Justice to be dealt with in a manner as prescribed by law.
But you see, Mr. Paul,
Balance.
if you interpret this order,
Balance.
it could be construed as
A reference, my lords?
as not as a reference,
My lord.
and also to regularize.
My lords, it cannot be regularized. That is what I'm submitting before your lordships. I'll take your lordships again back to the rules. Had it been, my lords, I had pointed out rule 9, my lords. If your lordships kindly have a look at rule 9 of the rules.
Look at the last line of this
My lords.
order. It says, in view of the order passed by the learned arbitral tribunal,
Place the matter
Yes,
before the
this
Chief
matter-
Justice.
it was
This
done
is to
so.
only for the
It
purposes
was
of...
done so.
No, my lords, it is done only for the purposes of bringing on record that there is already a reference. Because there cannot be two parallel proceedings in respect of the same proceeding, my lords. If your lordships kindly have a look at rule 9.3, we would be hit by 9.3, my lords, here. Single judge could not have referred the matter before the Chief Justice.
Just a moment.
The note, my lord, says that in view of.
See, the registry note also would say,
In view of, my lords. I've read the note. Your lordships will kindly say it says in view of.
where's the word in view of? Nothing.
My lords, towards the last part, if I remember correctly, my lords, what we had read.
Are you privy to this note?
My lords, because this is part of the official records, we had to examine why the matter has been placed before the this honorable court.
See, this is to bring to your lordship's kind notice that right order dated so and so in contempt case so and so. Honorable Mr. Justice so and so has been pleased to direct that this matter be placed before Honorable Chief Justice as the learned arbitral tribunal in its order dated so and so in arbitral proceeding also has referred the matter to this registry.
As the.
So,
My lords, as the joinder of both these two sentences as the, my lords.
yes.
Because the registry also notes the fact, my lords, that there is an order by the tribunal to refer. My lords, what I'm humbly submitting is, there has to be a reference before the registry of this court under Rule 9C for registration of this case as a, well, then it would be not registered as a cont case civil.
Please show me, see how reference is usually made.
Well, it's,
See the contents of how a reference.
a reference, my lords. Reference by a trial court.
Reference by trial.
I'm not equipped right now, my lords. I have it.
What would be the?
Do we have our iPad?
What would be the response of the registry?
My lords, if your lordships permit me, I was appearing in a matter before the Honorable Madhya Pradesh High Court, my lords, where there was a reference made by the district judge of the Madhya Pradesh High Court in respect to a criminal contempt matter. But the entire procedure has been laid down over there, my lords, and how the matter was then placed before Honorable the Chief Justice. Also, this Honorable Court, I don't know if there's been any reference by the trial courts. We'll just find out, we'll place it before your lordships. Because a reference has to be made specifically under, if your lordships kindly have a look at 9C. If your lordships kindly have a look at Rule 9C, my lords, that would clarify the matter.
I have something to say, my lord.
If-
I have something to say on this, my lord. My friend has something to say, my lord. Your lordship, if your lordship, the issue, if I...
My lords have Rule 9C.
Hey, 9C is.
Well, it's in the case of a civil contempt of a subordinate court on a reference made to it by that court. It is not open for anybody. My lords, I cannot come and say that there has been a violation of the orders passed by the trial court.
So now we are on a procedure
Lordships,
of how it is to be done.
lordships,
Since nothing is on record
my lords,
detailing such procedure,
my lords.
we would like to
I'll bring it on record, my lords,
by all concerned.
because I had appeared in that matter before the Madhya Pradesh High Court, my lords, and there we had thrashed out this proceeding as to how a reference is to be made.
May I say, my lord, the whole issue which my friend has raised is completely misconceived. Why it is misconceived, my lord? let me place my case, my lord. The
I don't know
lordship
what
say,
more cases
if
my
the
learned
lordship
friend will
thinks
place.
misconceived, how it is? Let me argue my case.
Please.
If the lordship says that the contempt can arise only by way of reference, not by independent proceeding. First, your lordship, the issue which falls for your lordship's kind consideration is that if the order under section 17 is violated by the party, then only in terms of reference matter can come. The party has no remedy to come before your lordship by way of contempt petition. For that your lordship need not travel far, because kindly see what is the direction in the order of the Honorable Tribunal at page 11, my lord. Kindly see the direction.
It's a question of referral, my lords. Where is the referral?
My first submission is, my first submission, I did not interrupt my friend. My first submission is that, my lord, reference which being construed here is reference for the purposes of initiating contempt, my lord, and at the same time, tribunal has also given me liberty to approach your lordship.
See, we are, Mr. Kumar, we are not on that. We are not on that. We are,
my lord, your lordship,
we are conscious.
this, my lord.
We are conscious of the fact that the tribunal has referred the matter. It is
That is one aspect of the
direction
matter,
direction is for the matter to be placed before the Chief Justice.
That is one aspect of the matter, my lord. And second aspect, your lordship, kindly
How-
see.
how
Second
it was-
aspect is whether
how-
liberty has been given to
see,
me
Mr.
to
Kumar,
raise before your lordship.
Listen, how it was done so and how it was not done so. That is
Your lordship, kindly
the
see
question
the
to be
order
answered.
again, my lord. If I kindly see the order paragraph. I'm
I
sorry.
would
I'm
only
repeating
pray your
again,
lordships
my
fix
lord.
a date. We'll place the relevant material and your lordships may hear us on that date.
Paragraph, my lord,
Hopefully
because
my learned friend will
humble
also be here physically.
Just-
That would make things a little easier.
My submission is that even without reference, contempt is maintained.
Where are you?
My submission is this.
Where are you at the moment?
Paragraph 5, my lord.
Where
at
are you,
page
Mr. Kumar?
12.
Where are you at the moment? Are you
Delhi, my lord.
are you
Niche
planning
matter
to
is listed.
are you planning to come to Shillong at some point of time?
I will come, my lord, but only thing which
We'll
I
take-
am
I
only
think
only
it'll be
with my
better
lord,
if-
your lordship is giving remote handle to contemner,
see, it'll
and
be-
I am concerned with that fact because contemner is in breach of the order. He is not explaining his conduct.
We are
He's
not
saying
on that.
Look, reference
We are-
is not
see,
available.
Mr. Kumar.
I will not go into the still you are in breach, and there is an order passed last year,
Let-
and that will not be
Mr.
implemented.
Kumar,
That
let-
is what he.
Let me repeat. Let me repeat myself. Let me repeat myself. We are not yet on that. Perhaps
Your
that
lordship
stage
should be on that.
That
My
stage will
humble
come.
submission, your
That
lordship
stage will
should
come, but not at this
that.
point. Not at this point. In fact,
Your lordship,
in fact,
what I say, your lordship, my case is that if your lordship reject my case that it is not maintainable, that is if my friends are
we will hear. You see, we have not concluded the hearing on the issue of maintainability.
Yes, your lordship, hear me, but I am only saying that please kindly consider these
Let us
aspects.
speak.
Ultimately, rule of
See,
law. Rule of law is this.
Let
is
us
a
be
rule of law which
let
is
us be
under-
clarified first on the query that has fallen from this court.
Well,
This matter was heard before.
before the learned single judge, yes, man.
Who relied on a decision of High Court of Delhi? This is a copy of the.
Yes, my lord. I have copy, my lord. I have relied.
Delhi
on
High
that.
Court, my lords, I have not relied. I think probably my learned friend could have
It has
relied.
been It has been referred by the Honorable Supreme Court, my lord. My friend will supply a copy.
It's all right. It's all right.
Which is the Delhi High Court? My lords are referring to 2009 DRJ, my lords.
One word, is 657.
Just a moment. We're just verifying some facts. So we'll take up this matter on next date.
My lords.
Your Lordship, can you speak? The Delhi High Court judgment has been approved in paragraph 7 of the Supreme Court. Paragraph 7 of the Supreme Court judgment.
We'll further hear the matter. Let
Yes, sir.
let the initial query be answered.
Yes, ma'am.
You suggest a date?
Monday, Your Lordship may have it on Monday.
My lords, may I pray your lordships have the matter on any dates, 18th or 19th, my lords, subject to your lordship's convenience. Or whether it would be convenient on the 22nd, my lords. 22nd is a Monday, my learned friend was praying.
I was praying for short date, my lord, because this has been hanging.
Monday
for
is
quite
after a
some
week.
time.
We'll have it on
18th,
Monday.
Your Lordship. 18th, Your Lordship may have it on 18th, my lord. 18th, my friend has suggested
No,
18th.
no, 18 we may have a number of
So
cases.
22nd then, my lords.
Yeah, 22nd.
Yes.
What happened to the reference? Has it reached?
No reference, my lords. That's what I'm submitting before your
No,
lordship.
no, whether the reference
My lords.
which was made by the tribunal, has it reached the High Court?
Not. The secretary of the secretariat of the tribunal has to refer the matter before your lordship, my lords.
So it is not reached. Though order is there.
My lords, never acted upon.
That was the question that was
The
asked.
Not
order
acted
says,
upon.
my lord, that I have placed it before the
Yeah,
order
exactly.
of the
Now, and
tribunal
we,
says I have
under,
to
we
place-
see, the point is understood. You are saying that the
And you
reference
see
has not
order-
reached. Mr. Kumar would say that reference is not,
My lords, one is an
not
order.
required since
My
the
lords,
petition
one
has
is an
been filed.
order. One is a separate reference
is
to be
why.
made, as your lordships have rightly pointed out. There's a reference. There's a format of a reference. Reference
the-
would then
the
require
order
certain
says-
things to be done, my lords. Secretary signs it. Maybe for the purposes of communication, it could have been done.
Things are not needed right now for us. So what for? What for we need to see these things? Once it will be seen when the reference is placed.
My lord,
Reference to come and needs to reach before Chief Justice. Then basing on Chief Justice order, it will not only place before approved branch.
then it would be registered separately also, my lords. 22nd. We'll try and assist your lordship.
Parties have been heard in this matter. However, on submission made, further hearing will continue on the next day.
Grateful, my lord.
This matter on 22nd.
Yes. Obliged.
Your Lordship, I beg to mention serial number 5. I'm yet to get contact with my client, so give me some more time.
Here for petitioner.
For the petitioner, my Lordship. At least for a week, Your Lordship, if you permit.
On permit by the petitioner. On permit by the learned counsel for the petitioner. Matter is adjourned. This is the matter. 3 weeks.
4 weeks, Your Lordship. 4 weeks, Your Lordship.
4 weeks.
It is, I have to contact through somebody, she does not have the number.
Doesn't matter. 3 weeks is good enough.
3 weeks.
You go yourself.
Okay, Your Lordship.
Only within Meghalaya.
Yeah, 3 weeks.
3 weeks.
My Lord, I beg to make a mention of item 3, my Lord. I am to file written argument. My Lord, it is not yet completed, my Lord. I am praying for a week's time.
Item 3.
Yes, my Lord.
This is that matter regarding the sports matter.
Oh,
Yes, my Lord. That maintainability. My Lord, I am praying for a week's time. I could not complete it, my Lord.
all the other parties have all filed.
My Lord, the others have filed, my Lord.
We have filed, sir, in CRP 28.
Mr. P.P. Burchaji, London GA, appearing for the state respondent.
In CRP 21.
You are in 21.
Yes, my Lord.
Appearing for the petitioner, state petitioner, to in 21 more.
21.
Sought for some more time to file the written argument on the ground that the same could not be prepared today. We allow this is matter of the 2 weeks.
Obliged, my Lord.
As far as 28 is concerned, everything is
Yes.
This is the only matter. I'll file it before the next date.
Your Worship, I beg to mention item number 8. There was a direction to the petitioner to file a status report of the construction project, but we would like to seek some more time to file the affidavit.
you are for petitioner.
We are for petitioner.
I believe
This
this matter has become infructuous.
No, Your Lordship, there and last hearing we have informed this honorable court that the construction is already completed, but as per our instruction now they said that no, the work is not
going on.
completed. It's still going on.
On pre-made by the General Counsel by petitioner, matter is adjourned. This is him after 3 weeks.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 4. Your Lordship, this is a connected matter with the WPC 363 of
2021.
2020.
We had it day before yesterday, Your Lordship. So, Your Lordship, this matter can be taken up on the same date as
24 July.
Oh, this is that Lokayukta matter?
Yes, Your Lordship.
yes, Your Lordship.
Why was it listed different dates?
It can be taken up on the 24th, Your Lordship. The matter is coming on 24th.
The other matters
The other matter.
on pre-made by the parties. This is matter on 24th.
Highly obliged, Your Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item number 9 and 10, Your Lordship. I pray if Your Lordship can have this matter after 2 weeks, Your Lordship.
This is that suspension
Yes.
suspension matter.
Yes, Your Lordship.
On pre-made by the General Counsel for the petitioner. Matter is adjourned. This system after 2 weeks.
How do you like?
Item 16, my lord. Item 16. Item 16, my lord, the matter is pending before division bench, my lord, and the matter has not been heard, my lord. So, on last date of hearing, also awaiting the order of the division bench, my lord, the lordship has been pleased to adjourn the matter. Item 16.
This is that check-gate matter.
Check-gate matter. Check-gate matter.
Mr. A. Kumar, learned AG, appearing for the state respondent, has submitted that a related matter is pending before the division bench of this court, and as such, this matter may be adjourned for the time being. As agreed to by the parties, matter is adjourned. This system after 3 weeks.
4 weeks may not be.
When is the matter listed? The other one?
It was listed on
Date
the
is
chart,
not
but
the-
however it is a holiday, so no new date has been uploaded yet on
4 weeks.
After 4 weeks.
But the 11, 12 and 14 with Mr. Jha, he's not around, my lord. 11, 12 and 14, my lord. 3 matters.
All related matters? Related matters?
My lord, 2 matters are related. 11 and 14. 12 is quite.
Mr. Jha has requested me to make a mention of these 3 matters, my lord. He's indisposed now.
Mention is made on behalf of Mr. R. Jha, learned counsel for the petitioner, who is said to be indisposed and could not appear for the court today. Accordingly, matter is adjourned. This is him after 2 weeks. 12 and 13.
My lord, item number 13, lordship, we seek some accommodation. Item number 13. London AG also consented for. Lordship, give me a week's time.
What is this fixed for?
This matter relates to suspension of a teacher.
Matter has not been heard.
No, it has not been heard, Your Lordship.
So how long? 2 weeks time?
2 weeks time.
On pre-made by Mr. H.L. Sangresu, learned senior counsel, appearing for a petitioner seeking accommodation. The same not be objected to by the respondent. Matter is adjourned. List is same after 2 weeks.
Lordship, I beg to mention item number 18. Lordship. For 3 weeks time, Lordship.
What is this matter about?
Same matter, my lordship, is disposed of on contempt matter, my lord.
His pass certificate.
Pass certificate?
Yes, sir.
In what sense?
In what sense is that he had submitted his thesis, though that period has not been included in his certificate. That period only.
But is it totally connected with the contempt, my lord?
No, not
after the
Lordship, it is
contempt
not.
has been decided, nothing remains in this petition.
Not at all.
Oh, contempt may have been decided.
Contempt is different.
But the fact means that if there is something wrong in the issuance of this certificate.
But if the lordship had found something wrong in the contempt, the lordship have taken cognizance in there itself. There is absolutely nothing, my lord.
It is submitting.
Your
In fact, I prepared
I will
this
place
matter
my
yesterday.
case, Lordship.
Although here what happened, my lord? He was
In the
supposed to
morning.
complete his MD in 3 years, my lord. He completed that in 6 years. Then he came before this honorable court that he is not able to submit his thesis and all that. This honorable court further granted him extension by 1 year. Lordship,
No, not granted at all.
I'll just complete. So finally he submitted his thesis, examined, he has passed out, he has gone back. Now he wants a residency certificate, senior residency certificate for the entire 6 years. If somebody delays, my lord, in submission of thesis what is supposed to complete within 3 years, he completes that in 6 years, and then says, no, you have to give me a certificate, experience certificate for that period, which is not permitted in the rules.
But that is the issue.
That's the issue.
That is the issue.
You will hear the matter.
Yes.
How long?
Because 3 weeks, Lordship. Because after the order of this honorable court, he had submitted the thesis. That period is also to be included. After that, again he was appointed. All those are there, Lordship. Messi, under the facts and circumstances, he is entitled for the relief.
Extended the time for submission of thesis. No, not to increase his experience certificate, my lord.
What the extension entails, we don't know. We'll see. We'll look into that issue.
What about it's unnecessary pending, my lord? Can we taken up next week, my lord?
Well, 3 weeks time may be given, Lordship. Since I have failed in one case, Lordship.
We need some sustenance.
Yes, he may
now,
engage a senior
my lord,
counsel
one
also.
more aspect, my lord. He filed 2 writ petitions at the same time, my lord. Those 2 writ petitions are also connected, my lord.
Lordship has recused one. So this is pending. So that is also
more or less
same identical. So this writ petition should also means according to
yes.
as
Then
per my understanding, Lordship, it could be heard in another bench. Because in 418 Lordship has recused because some of the
other matter was recused because
some of the respondents.
Are
yes, Lordship. So in this
same here.
So respondents' names are mentioned in this also. Therefore,
what do we do then?
So, my lord, if Lordship directs, it can be heard to because more or less identical matter, my lord. That is WPC 418, my lord. Lordship direct for listing it along with 417, 418.
What is except I recuse cannot be directed because
no.
This court cannot. It has no administrative power to.
Yes.
Because court number 2 also will not take up this matter because he was mediator in this matter, my lord. Justice, thank you.
That matter was taken up by which court?
That
court
number 4.
I think it will go automatically.
Okay, I'll recuse them.
Lordship.
To 18. Upon hearing the learned counsel for the parties, wherein it was submitted that, it has been submitted that a similar matter pursued by the petitioner herein is pending before another bench of this court, which matter was not taken up by this court on the reason stated therein. Therefore, it is the considered opinion of this court that this matter be listed before any other bench except this court. It has been listed any other bench.
Lordship may direct for clubbing together, my lord.
No.
But how can I direct it?
That will be not.
The registry will have to do that.
Well,
yes, Lordship.
Otherwise, the Chief Justice will have that prerogative. But that can be,
that will come up, and in another bench we will mention, Lordship.
You can mention it before
yes,
the
yes.
bench. Or you can talk to the registry.
WPC number 418 can be mentioned, my lord.
Yes, the writ petition number could be mentioned.
418 or
2022.
That is WPC number 418 2022. Fine. Before it is also the submission of the parties that this petition as well as WPC 418 of
2022
similar and related. Perhaps the same could be taken up together. Are they related?
It's identical, my lord.
Identical, lordship, because pleadings are more or less same, but here the relief is different. There the relief is different.
Order accordingly.
Applies to.
Your Lordship, I beg to mention item number 17. Pray for 2 weeks' time, Your Lordship.
Your for?
For petitioner.
On pre-made with petitioner. Matter is adjourned. Let's see after 2 weeks.
May it please Your Lordship, I beg to mention item number 6, Your Lordship.
Number?
Number 6, Your Lordship.
6.
I pray if this matter can be taken up after 2 weeks, Your Lordship.
It's an old matter.
Nehu matters.
Yeah, Nehu matter. I think some other related matters have been
Disposed
disposed
of.
of.
Your Lordship.
I think this is the only.
It's left, madam. Yes,
Why would we?
next week, madam. 2 weeks, Your Lordship.
Miss the counsel for the respondent has sought for time to be heard in this matter on grounds of personal difficulty. The prayer not being objected to by petitioner seems allowed. This matter up to 2 weeks.
Right, Your Lordship.
On supplementary cause list, item number 1.
We'll take up the matter after the
End of the board, last item.
not end of the board, but before the hearing of the of the main list.
Right.
Because there's an order matter here, and let me
Right,
dispose
right.
of that matter. We'll take it up.
On daily list, item number 1.
Please, Your Lordship.
Yes.
Your Lordship,
This
I'll take Your Lordship to the last order, Your Lordship.
Your Lordship, this matter
Order
will be
dated
disposed of.
19/6.
Yes.
Your Lordship, I'll read the last paragraph of Your Lordship's order. This court on consideration of the submission
Your
made
Lordship, this matter
and-
may be disposed of. Your Lordship. Order already passed. Order already passed. Your Lordship.
What order for? Yes, Mr. Oh,
I'll just read the last paragraph of Your Lordship's order, Your Lordship.
yes.
This court on consideration of the submission made and also taking note of the order dated 17/5/2024 passed by the Honorable Supreme Court in SLP number so-and-so would agree with the learned counsel for the petitioner that the doors before the apex courts are now closed to the respondents as far as the matter is concerned. The respondent is under obligation to comply with the said order dated 7/2/2023. It is therefore directed that the respondents take necessary steps in this regard, failing which necessary orders or directions will be passed in this matter. After the orders passed by this Honorable Court, Your Lordship, the Ministry also has written some letters to the DGAR to comply with the order. And then there are some instructions also from the DGAR that this orders has to be complied with. Now, as far as the situation at present is concerned, Your Lordship, is that only the paperwork has been done, but in so far as implementation of the order, it has not been carried out. So my humble prayer, Lordship, since the paperwork...
Mr. Nongri, are you aware of this order passed dated 8 July?
Yes, Your Lordship.
This is the one, Mr. Devnath?
Yes, Your
Yes, yes, I have a copy, Your Lordship.
So this order,
Paragraph 5 of this letter, Your Lordship, 8 July 2024.
yes,
In pursuance whereof, the following actions will be taken by the concerned branches of headquarters DJR to ensure full compliance of the High Court of Meghalaya judgment order dated 17 Feb 2023, passed in WPC 198/2019, holding of board of officers for implementation of the above mentioned order by introducing rank of assistant sub-inspector, warrant officer rank in Assam Rifles in respect of 192 petitioners only in the pre-revised scale of so-and-so, Lordship, from the date of enrollment. Preparation of fresh individual pay statement, IPS, and fixation of pay thereof, as per relevant rules of the CPC due to change in basic pay of the affected persons, 192 petitioners only. Calculation of errors due to individuals, preparation of errors, and make payment thereof. MACP drawn by any individual may be rechecked, recalculated as per existing policy. It is to be ensured that the standing and seniority of clerical cadre rate personnel as well as pay structure commensurate to their seniority with 89 other clerks who have already been designated as warrant officers by administration order dated 1st April 2019 issued by headquarters DGR in this regard be maintained. This order is issued with approval of the Ministry of Finance, Department of Expenditure, so-and-so, dated 18 June 2024, and Ministry of Home Affairs, dated 25th June 2024. So there's not much left, Your Lordship, in my humble submission. So they only have to implement now, which will not take.
So we'll give them time to implement then.
Your Lordship.
Or so in view of this, we would consider this contempt petition disposed of.
Your Lordship.
Would we consider
No,
this?
Your Lordship, we'll keep it pending, Your Lordship, till
There is nothing remains, Your Lordship.
They'll play some tactics here and there, Your Lordship.
Your Lordship, in view of this order, this contempt petition will close, Your Lordship.
You should not play, as he said, don't play tactics here and
No,
there.
Your Lordship, here is specifically given for
Mr.
192.
Devnath, I think better place this by way of an affidavit. Place this order by way of an affidavit and ensure that implementation is done at the earliest. I think
Your Lordship, this order is very much clear, Your Lordship, for 192 only. This only the petitioners 192 only for them, not for others.
Exactly, only for them.
Yes, only 192. We bring only for 192. Your Lordship, 2 weeks thereafter they can submit the status report as to what have they done.
Heard Mr. R. Devnath, Leonard CGC, who has submitted that.
Your Lordship, for IPS people and others, it will take time, Your Lordship.
Just a moment. Has submitted that the relevant authorities in the Assam Rifles, relevant authorities, taking cognizance of the facts and situation as is apparent in this contempt petition, has accordingly decided to implement the judgment and order dated 17/2/2023, passed in WPC number 198 of 2019. An order to this effect has been passed by communication number to EMO dated 8 July 2024. The Leonard CGC has, however, submitted that some time may be allowed for the complete implementation of for the process to be completed, which may take some time. Mr. P. Nobri, learned counsel for the contempt petitioner, has no objection to the submission made and has submitted that the relevant respondent authorities may be directed to complete the procedure at the earliest, preferably within 2 weeks.
You will see in 2 weeks it will not.
Yes, ma'am. This court, on consideration of the submission made, would firstly urge upon the learned CGC to place the set order dated 8 July 2024 to place on record the set order dated 8 July by way of an affidavit. As far as the period for the implementation of the said order, being mindful of the time to be taken in the administrative work, the court would allow the prayer of the learned CGC and direct that the whole process be concluded within 4 weeks from today. This is matter of 4 weeks. MD, learned CGC is also directed to file a status report within the next date fix. This is matter of 4 weeks. You should do it earlier. You see, this matter it's a long pending matter.
Oh, Your Lordship, or one more line can be added or face the consequences.
Mr. We are already on the contempt. So why would a contempt upon a contempt be
It's only more than 1.5 years, 2 years, Lordship.
Mr. Devnar will do it. Don't worry.
Obliged, Lordship.
From supplementary list, item number 1.
1 and 2 same.
Same here.
This matter has been heard?
It was heard. Heard partially, my lord. Then in the course of hearing, it was felt necessary that I prepare a chart, my lord, a list of dates.
Yes, please.
That picture. This is a revision application, my lord, filed against an order passed by the special judge, my lord, CBI, whereby the learned trial court has discharged all the accused persons, my lord, all 5 accused persons. Well, in the case there are 5 accused persons, my lord, 3 officials of the NEC, my lord, Northeastern Council, and 4 and 5 were the principal and vice principal of St. Peter's College, my lord. Case arises from some project, my lord, some science project that was sanctioned by NEC in favor of St. Edmund's College, and the sanction amount was roughly 5 crore rupees, and that was in the year 2005, my lord. Here what happened, my lord? That 5 crore rupees was sanctioned and this was supposed to be released in installments. So first installment of about 48 lakh rupees was released. They submitted a utilization certificate. We are lots of aware installments are released on submission of utilization, my lord. So they submitted in the year 2005 one utilization certificate saying that the 40 lakh has been utilized. Now we release the second installment. On the basis of that, my lord, a second installment was released. Then after a few months, they again submitted a utilization certificate saying that that money has been utilized. Now release the third installment. A third installment of about 2 crore rupees was released to them. What transpired, my lord, that there was misappropriation of fund. Money was spent in the heads which were not within the ambit of the project. So much so that a land was purchased by the St. Peter's College, my lord, amounting to rupees 2 crore rupees something out of that money. So when all these things came to light, my lord, now I'll take your lordship's attention to the list, my lord. So my lord, just to sum up that, so my lord, what happened? CBI conducted a preliminary inquiry, registered an FIR, submitted a charge sheet, my lord. After the charge sheet was submitted, the learned trial court, prima facie being satisfied with the charge sheet, my lord, directed for framing charges against all the 5 accused persons. Against accused number 1, 2, 3, that is the NEC official, charges were duly framed by the court, my lord. 4 and 5 were somehow trying to evade, so charges could not be framed against them. They came before this honorable court, my lord, at that point of time, in the year 2011 or 12, my lord, saying that they have some material which will absolve them from the case. So allow them to produce those documents before the trial court at the stage of hearing of consideration of charge, my lord. This honorable court rejected that application, my lord. But I'll take your lordship just briefly, my lord, to that particular order passed by this honorable court, my lord. Page 116, my lord. Operative parties at page 116, my lord. In fact, 115, my lord, the previous page, lordship kindly. Page 115, minute. Yes. I'll just refer to para 50, 51 and 52, minute. 3 paragraphs. Yes. Coming back to our case, I found that materials on record prima facie reveal that the proposal on project research based holistic cluster approaches at grassroots level for sustainable development in NER was processed in violation of relevant rules, and thereafter an amount to the tune of rupees 2 crore 67 lakh was caused to be released by NEC to St. Peter's College, Shillong for implementation of the aforesaid project. Such materials further appear that an amount to the tune of rupees 1 crore 26 lakhs and so was shown to have been spent on 5 targeted villages in the state of Assam, Meghalaya, and Arunachal Pradesh, and same appears to have been shown on the basis of forged fabricated documents, and in that process they as public servants gained something which they were not legally entitled to. Being so, in my considered opinion, the framing of charge under the aforesaid provisions of law cannot be faulted on any count whatsoever. In view of the above, I am also of the opinion that the accused petitioners could not make out a special case for invoking the provisions of Article 227 of the Constitution of India to set aside the order dated 31/1/13 passed by the learned special judge, holding that material on record the accused petitioner can be presumed to have committed offence under section so and so, read with PC Act so and so. Well, after this order was passed, my lord, somehow, my lord, I think only they can explain, my lord, a miscase was filed, my lord. My lord, kindly see page 117, my lord. The very next page, my lord.
Yes.
And by this very lengthy order, my lord, this honorable court, I'll just take to the operative part, my lord. At page 152, my lord.
Yes.
Para 24, I'll just read the operative part, my lord. For the foregoing discussions, in the given case, the trial court can look into the material evidence produced by the petitioners accused at the time of framing of charge, and the core question number 1 formulated above is answered accordingly. The core question number 2 formulated above is also answered that this court can exercise its jurisdiction under section 482 CRPC in the present revision petition, and present revision petition is maintainable. Corollary of the above are that the trial court shall look into the documents mentioned above and also the documents annexed to the revision petition if not suspicious at the time of consideration of the charge or at the time of consideration as to whether or not prima facie case against the present petitioners have been made out. The accused petitioners are to place the document mentioned above and documents annexed to the present revision petition before the trial court at the time of consideration of the charge. So this honorable court allowed them, especially only accused number 4 and 5, my lord. These applications filed by St. Peter's principal and vice principal to place additional document at the time of consideration of charge. Now, of course, I cannot ask your lordship to review or reopen this order. This order has been passed, my lord. But only thing your lordship will notice that documents, if not suspicious in nature, my lord. So that I have to confine my argument only to that because we cannot go behind this order, my lord. Now, my lord, after that, they filed those new documents, my lord, were taken into consideration by the trial court, and taking into consideration those documents, my lord, the learned trial court discharged all the accused persons, my lord. In between, what had happened, my lord? One order which may be relevant, I'll just point that out, my lord. At page 157, my lord. It starts from 155, this order. It starts 155.
155.
My lord. So, my lord, as submitted, my lord, the charges were framed against A 1, 2, and 3. 4 and 5 charges were not framed, my lord. They came before this honorable court. This honorable court allowed R4 and R5 to adduce additional documents at the time of consideration of charge, my lord.
To produce those documents.
So this liberty was given to 4 and 5 only, because 1, 2, and 3 charges were already framed. So 1, 2, and 3, not 1, my lord. What 2 and 3 did, they filed an application before the trial court relying on the High Court's order. So the trial court allowed accused number 2 and 3 also, my lord. I'll just refer to the operative part, my lord, at page 157.
Yeah. Page
157.
Yes.
The last paragraph, 2-3 lines I'll just read. Yeah. In view of the above, petition number so and so is hereby allowed, and the charges framed against the accused person Albert D. Kharshin and R.P. Kharpuri, they are accused 2 and 3, my lord,
yes,
are to be considered afresh.
Yes.
And they can now place the documents relied by them at the time of consideration of charge. Now, how far this order is proper, my lord, that is one aspect.
But was this order challenged?
This order was not challenged, my lord. This is not challenged now also. But one very interesting part remains, my lord. Accused number 1, against him charges were framed, my lord. he is not a party to this order. Accused number 1 also has been discharged, my lord. Neither there is an order by High Court in his favor, nor by the trial court in his favor. But even after framing the charge against him, he has simply been discharged in a lot, my lord. All 5 have been discharged by the impugned order. But this is only a technical aspect your lordship will.
But you see, where is that the relevant orders? Whereby he was discharged?
That is the impugned order, my lord.
Oh, that's the impugned order.
That is the impugned order. All 5 were discharged, my lord.
In spite of the fact that charges were already
framed against him. He was not given any relief by the High Court, my lord. High Court only 4 and 5 came for additional document. 2 and 3 went to the trial court. Trial court said that okay, we'll examine your charges afresh. So 1 remains, my lord. That is but our entire thrust is not on accused number 1, my lord. We are challenging the entire discharge of all the 5 accused. Now, my lord, some dates are relevant here, my lord. I'll just refer to the chart, my lord.
Yes.
My lord, in this case, there was a preliminary inquiry, my lord. And that preliminary inquiry culminated into registration of FIR. FIR was registered on 6/5/2009, my lord. The date is...
Yes.
But the FIR was registered on 8/5/2009, my lord. The second date, my lord. Now, my lord, when the inquiry was going on, my lord, the preliminary fact-finding inquiry was going on, just before registration of FIR, my lord, and without keeping the CBI in loop, what accused person sensed, my lord, when the inquiry was conducted, that they will be in trouble. They may be in trouble. So just before the FIR is registered on 8th May, on 6th, what they do, my lord, they start firefighting. And they try to undo what they have already done, my lord. So on 6/5/2009, as I submitted, my lord, in the year 2005, they submitted the utilization certificates. And on 6/5/2009, my lord, what did they do? The college authorities, they write to NEC, my lord, that we want to withdraw those utilization certificates. Now the question, my lord, for lordship's consideration is whether a utilization certificate which has been acted on, my lord. And utilization certificate is not a domestic letter that you can change any time, my lord. This is supported by audit statement by a chartered accountant, my lord. And once they sense that they'll be caught now, they write a letter to NEC. And our lordship will appreciate that the NEC people are also accused persons, my lord. And your lordship also, the correspondence is among the accused persons only. Once they sense the trouble, my lord, once they can feel that there is going to be trouble, now they, in total collusion again, my lord, they try to undo what they have done earlier. So cheating that was already committed, the fraud that was already committed, now they are trying to return the money. Return the money by again saying that no, that utilization certificate was not correct, we will give you a fresh utilization certificate. So my lord, 6/5/2009, so that is why the argument was, we stopped on the last occasion just to correlate the dates, my lord.
Okay.
So my lord, here is a direct correlation because fact-finding inquiry was already started by CBI. FIR was registered on 8/5/2009. Just 2 days before that, college authorities write to them, my lord, that please treat that as irrelevant, null and void. We'll give you a fresh utilization certificate. My lord, as I submitted, can utilization certificates which have been acted upon, which NEC accepted, and after accepting that has released the second installment and third installment. And can those official documents be changed after 4 years, my lord? Now, my lord, So I'm trying to confine my argument only that whether these documents. So what they do, my lord, they first on 6/5/2009 they write that we withdraw or you cancel as a null and void all our utilization certificate. We'll give you a fresh utilization certificate. And when do they give that fresh utilization certificate, my lord? My lord, kindly see. 12/11/2010, my lord.
Yes. This is the revised, you see.
Submit a revised utilization certificate to NEC. They submit it to NEC, my lord.
Yes.
Who are also accused persons, my lord.
Yes.
And lordship will kindly note the date, my lord. We submitted the charge sheet on 30/7/2010. Just one row above that, my lord. 30th July we submit charge sheet, my lord.
Yes.
On 12th November 2010, they submit the revised utilization certificates, my lord. My lord, thereafter, as I already submitted, but the trial court directed to proceed with framing of charge against all the accused person. If you lordship want, I can. So should I refer to the orders, my lord?
Yes. What is the reference?
But only that initially that learning trial court directed that they were filing application after application. Learning trial court held that these are all dilatory tactics, and court will proceed to frame the charges against all the 5 accused persons. There is a specific order to that effect, my lord.
Okay.
Now after that, my lord, charges already framed against 3 of them, my lord. 2 as a submitted, my lord, came before the honorable court. So that is the sequence, just to indicate, my lord. Now I'll just refer to few parts, my lord, in the impugned order itself.
Yes.
My lord, I'll refer to page 186, my lord, as a part of impugned order.
Yes.
So lordships will find here the details of the utilization certificates, my lord. Utilization certificate dated 15/6/2005. Page 186, my lord.
Yes, 186.
But just after first para, my lord, serial number A.
Yeah.
A different page, my lord.
Yes, yes. 186.
Yes.
Para 72 or 73 or
Para 72, my lord.
72.
Just after that, my lord, serial number A, utilization certificate dated
Yes.
15/6/2005, 4 rupees 47 lakh.
Yes.
So this utilization certificate was acted upon. NEC after receipt of this utilization certificate released the second installment of 67 lakh rupees, my lord.
That is 26/7.
And that is the second utilization certificate they gave for 67 lakh rupees, my lord. On the basis of that, my lord, then serial number D, audited receipt and payment account dated so and so, 4 rupees 200 lakh. So another 2 crore rupees were released on the basis of second utilization certificate, my lord. Then the trial court records, my lord, at para 73.
Yes.
That all these above utilization certificate and audited statements were withdrawn by the college.
Which page are you referring?
186.
Yes.
By their later dated 6/5/2009. As I pointed out, my lord, FIR was of 8th May and they withdraw it on 6th of May, my lord. and that also without informing CBI, my lord. Now, my lord, second relevant document, my lord, which they rely, page 192, my lord.
Yes.
This is also the document which found favor with the trial court, my lord.
Later dated
27/6/2009. This says, my lord, when they are caught that money of was spent for purchasing land, my lord.
Yes.
So what the college does, my lord? College writes a letter to NEC.
Yes.
And my lord, kindly note that letter is addressed to Director SNT NEC. And he himself is accused person, my lord. So one accused person, just to dilute the matter, my lord, is writing a letter to him. He gives a favorable reply. He writes a favorable letter to him, so that the matter is diluted. And after doing all kind of crime, my lord, they among themselves, they very happily they're exchanging letters, my lord. I'll point out, my lord, what they're doing. It says, my lord, this is a reference to your office letter above dated 16/6/9 and 25/5/9, all on or about the registration of FIR, my lord. The accrual expenditure incurred specifically against NEC sanctioned release so far are as follows: 67 lakh towards R&D, so and so. My lord, the last paragraph, it may be clarified that the land building component has been solely contributed by us from our end as our contribution. Once they are caught, my lord, that money was diverted to buy land. Now they clarify that okay, land will contribute from our side, will not use NEC's fund for that. Whereas they actually use NEC's fund for buying the land, my lord. Then, my lord, on the next page again, lordship will see 28/8/2009.
Yes.
This is a letter again, a very nicely written letter, my lord, to dilute the case by principle of one accused to Director SNT NEC, my lord.
Yes. What does this letter say?
This says, my lord, the last paragraph I'll just point out, my lord. We take pleasure in inviting you to come and visit these at your convenience, and to please help us to include the paleontological studies in the program of research, and this is your special field of professionalism. So very happily they're writing to each other, my lord.
What is the relevance of this?
But the relevance is, my lord, this is a chain of letters, my lord. The London trial court has relied on these letters, my lord, to discharge the accused persons. On next page, my lord, the another document which has been relied on by trial court.
Yes.
It says, my lord, this is again written by, this is by CBI, my lord, to the Director SNT. Please refer to your letter number so and so forwarding photocopies of detailed expenditure voucher, ledger accounts, etc. against the sanctioned release of 2.67 crore. Reference may also kindly be made to your letter number so and so submitted earlier, forwarding copies of detailed expenditure to this office, where total expenditure incurred have been found to be rupees 3.33 crore approx. In this connection, you are requested to kindly clarify the following: if the expenditure of 2.67 crores sent via your letter number so and so have been accepted by NEC as eligible under the scheme, if the expenditure of 3.33 crores sent via your so and so have been accepted by NEC as eligible under the scheme, whether the expenditure audited by CA for so and so crores, verified by R&B company white so and so, certified by Susanta Roy and company white dated 26/7/2000 have been accepted by NEC, and whether the purchase of land is eligible under the scheme. Now, my lord, now the Director SNT, who is accused person, my lord, gives a reply to CBI. Next page, my lord.
Yes. Yes.
So basically, what they are trying to do, my lord, they are trying to dilute everything and trying to cover up.
Yes.
Now, What they do, my lord, after committing the crime, my lord, what they do, they ask for justification, explanation, whether you accept it, is it eligible or not. If not eligible, we'll return. But as if, my lord, after stealing something, when police catches him, then he makes a telephone call, oh, your thing is with me, please come and take it. In non-compoundable, but here what trial court has done, my lord, as if the matter has been compounded between NEC and St. Peter's College, so close the matter. My lord, under PC Act, there's no provision, though the order doesn't say that matter has been compounded, but your lordship, I'll take your lordship to the order and the finding of the trial court. The court has proceeded on the basis that if the matter has been almost compounded, NEC has no problem. And who is NEC, my lord? The NEC as an entity is not involved here. My lord, only the same 3 officers, my lord, of NEC who are also accused person in the case, who are also charged. These 2 from St. Peter's and 3 from NEC, my lord, all correspondence among themselves, my lord. He writes to NEC, NEC gives a very favorable reply, and all that after, during the course of investigation, my lord. So, my lord, my case is only confined to whether these documents can be regarded as unsuspicious documents, my lord, or documents which have been created later on, my lord, after the FIR and after investigation, and some documents even after filing of charge sheet, my lord. Whether such documents can be relied on by the learned trial court for discharging the accused persons, my lord. At page 201, my lord, the most important document which they've relied on, my lord, to discharge.
201.
201.
Para?
90, my lord.
Yes.
It says, my lord, then the college on 22/7/2010, my lord.
Yes.
The dates, my lord, kindly note, my lord. These are all after investigation is started, my lord. On 22/7/10, submitted to NEC the consolidated account statement, audited accounts for the period 2005 to 2009. After recalling and withdrawing the earlier ones, my lord, they submit a fresh document along with remainder voucher so and so. College submitted the consolidated utilization certificate dated 29/9/2009. My lord, kindly note the date of new utilization certificate. This is also after registration of FIR, my lord. And then the trial court, it is seen that all these were totally ignored in the charge sheet. That is the allegation against us, my lord.
But charge sheet has already been filed.
Charge sheet has been filed, my lord. I pointed out the date, my lord. 30 July 2010, my lord.
How can they be ignored? They have not been considered at that point of time. Anyway, that's...
My lord, this document is addressed by college to NEC, my lord. You are all friendly with NEC people, so they are all hand in gloves, my lord. So there are.
Who's in hand in gloves?
Now, my lord, I'll just. Well, one relevant aspect in my chart I mentioned, my lord, who are the accused persons. So, my lord, that will throw a lot of connections, my lord, how things are working. Accused number 1 is the financial advisor of NEC, my lord. 2 is extension officer NEC. 3 is director, science and technology, my lord. Now, lordship will loss is seen, all these correspondence are by these three accused person to the college, and from college to these three persons, my lord. Now, my lord, what the trial court is held, my lord, I'll just even operative part is pretty long, my lord. But I'll just, the operative part starts from 188, my lord.
Page
188.
Yes.
Para 80 onwards, my lord. Should I read, my lord? These are around 20 pages.
Oh, what do you want to?
I want to show the learned trial court relied heavily on these documents, my lord.
So that you see,
my lord.
You see that you have referred to just now.
Yes, my lord. Some of them I've referred to, my lord.
Yeah, paragraph, those letters and
my lord.
The observation made by the trial court. So the summons,
I'll just read few paragraphs, my lord.
See, the sum and substance of this impugn order is this, that the trial court
has relied on the documents which were in my humble submission were somehow manipulated among themselves between the accused persons 1, 2, 3 and 4 and 5, my lord, to dilute the case. And the learned trial court has accepted these documents, my lord. My lord, in my submission, humble submission, my lord, the law laid down and was this honorable court on the basis of which allowed to produce additional documents, unimpeachable documents, my lord, beyond suspicion. A document which is a very designed document, my lord, for a particular purpose, after registration of FIR, after investigation is started, and who the correspondence, these are not independent correspondences, my lord. These are the correspondences between among the accused persons, my lord. Because 1, 2 and 3 also know, my lord, if they don't help 4 and 5, they'll be caught.
See, here is a situation,
my lord.
Investigation has commenced,
my lord.
Charge sheet has been filed,
my lord.
In the meantime, the accused person wishes to introduce certain documents which were not considered during investigation, according to them.
My lord, these were the documents created around that time, my lord, when the investigation is going on.
That's beside the point.
My lord.
That's beside the point.
My
the point is, they wishes to introduce this document for the IO to look into this document, and thereafter, perhaps the report or the charge sheet might might be in the favor, whatever the case may be. But the fact remains that after the charge sheet has been filed, these documents came to light, and the court has directed that these documents be considered at the time of consideration of charges. So without verifying the authenticity or the importance,
whether these documents are really genuine documents or these are created for certain
that should be the role of the IO.
But my lord, some of the documents came to light only after filing of charge sheet.
Exactly. See now, under section 173(8) CRPC. See, the court, the IO can make a submission for reinvestigation or further investigation of the matter after charge sheet has been filed.
So, my lord,
so we take it that these documents were introduced by the accused. That's irrelevant. The point is, it is the incumbent upon the IO to look into these documents and see whether the same have been made or have been introduced in the case to give a clean sheet to the accused person, or they are, as you said, suspicious in character. That has not been done.
Well, here
What the trial court, if I understand correctly, what a trial court would do is they have taken note of these documents and have come to a conclusion.
A different conclusion and discharge them. At the least, trial courts would have asked the IO to reinvestigate the matter,
Exactly. That's what
take into consideration these documents, and then submit a supplementary charge sheet or whatever is to follow, my lord.
I think 173.8 would see that. Yes. So this is also in the realm of obtaining further evidence
My lord.
after the charge has been filed.
My lord, why this is important, my lord? If your lordship kindly looks at the chart, my lord.
Yes.
My lord, kindly note that charge sheet was submitted on 30 July 2010, my lord. 30/7/2010, my lord. The most important defense document, my lord,
Yes.
which is the revised utilization certificate. That your lordship will see on the next column.
Yes.
12/11/2010, A4 and A5 submit revised utilization certificate to NEC white letter dated 12/11/2010. And this document is relied on by the trial court, my lord, without examining the nature and character of those documents, my lord. Whether these are authentic documents or the documents created by accused persons to help each other, my lord, to come out of the case, my lord.
And that is the factual aspect. Now you have to cite the law which says that the trial court could not have done so.
My lord, this honorable court, while referring the matter, allowing them, has relied on a decision, my lord. I'll just take a lordship to that particular decision, my lord. Page 151, my lord. This honorable court is referred to those decisions.
Yes.
Para 22. The apex court in so-and-so had considered as to when defense case to be considered and heard. The apex court in Anita Malhotra case supra clearly held that though it is not proper for the High Court to consider the defense of the accused or conduct a roving inquiry in respect of merits of the accusation, but if on the face of the document which is beyond suspicion or doubt, well, these are the words, my lord, suspicion or doubt, placed by the accused, and if it is considered that the accusation against her cannot stand, in such a matter, in order to prevent injustice or abuse of process, it is incumbent on the High Court to look into those documents which have a bearing on the matter even at the initial stage and grant relief to the person concerned by exercising authority under 482. But this will not otherwise also apply. This is the power of the High Court, my lord. From the ratio laid down by the apex court in Anita Malhotra case so-and-so, it is clear that in order to prevent injustice and abuse of the process, it is incumbent of the High Court or the court to look into those documents which have a bearing on the matter at the initial stage. Therefore, it is clear that there is no straitjacket formula that a trial court has to consider only the charge sheet and the document relied upon by the prosecution and not the documents produced by the accused at the time of consideration of the charge. The apex court in Harshendra Kumar so-and-so, from the ratio decidendi, it is clear that in appropriate case, if on the face of the documents which are not suspicious or doubt placed by the accused, accusation against him cannot stand, the court for promotion of justice or to prevent injustice or abuse of process can look into the materials which have significant bearing on the matter at prima facie stage. The framing of charge under Section 228 of CRPC, as clearly discussed above and held by the Apex Court in Anita Kapoor case, is at the stage of prima facie case. As such, even at the time of framing of charge in a particular case, the court can look into the defense of the accused or the documents produced by the accused for the foregoing reasons, so and so, so and so. So, my lord, the proposition of law, we have no dispute, but the documents, if court is relying on, my lord, the court should be satisfied. At least there should be some observation by the court that these documents are genuine. These are not malicious document. That there is no finding to that effect in the entire order by the trial court, my lord. Learned trial court took the documents as if these are proved documents, my lord. But are those documents not required to be proved in court in accordance with law, my lord? Are we not entitled to examine the author of the document, whether these were voluntary and with what intent and with what design these documents were, these letters were written, and how utilization certificate could be changed after 5 years, my lord. That also after filing of charge sheet, they change the utilization certificate, my lord. They submit a utilization certificate after 5 years. After filing of charge sheet, NEC accepts that, my lord. The same people, my lord. But they also know that if they don't accept it, they'll be in trouble, my lord.
So what you're trying to project is that, you see, there is a case of manipulation here.
It is a case of manipulation, my lord. These are manipulated documents and manipulated in a very concerted design. My lord, if this is permitted, my lord, somebody steals money, my lord, or misappropriates money, then investigation starts. Then he comes, okay, you take back money, I'll give you a fresh utilization certificate. My lord, if that is permitted, in that case, every prosecution will fail, my lord. Once somebody is caught, my lord, if he is permitted in non-compoundable offences, my lord, to say that, okay, you take back the money, I'll give you a fresh bill, fresh challan, a fresh voucher and all that. My lord, can that be permitted, my lord? After the process of law has been set in motion.
See, but even in that situation, any observation made by the court would be based on surmises. Because you cannot, see, nobody, the court has no facility to authenticate those documents, whether they are genuine or not. What is the intent? What do you have submit is, what is apparent is there is some conspiracy between the accused or amongst the accused.
To get out of the case, my lord.
To make out a case for themselves. But that would not be the duty of the court to verify such facts.
But my lord, at least court court will at least verify, my lord, can utilization certificate be changed after 5 years? Are there no rules for that purpose, my lord? There must be financial rules. There must be some guidelines for that utilization certificate once accepted cannot be changed after 5 years.
Court should have directed for fresh investigation or supplementary charge sheet to be filed.
Documents accepted, my utilization certificate accepted 5 years back.
True.
And after filing of charge sheet, they write very friendly letters to each other, my lord, and say, no, I'm giving a revised this thing, and land also which we purchased, okay, we'll treat as from our money. But if that is permitted, if that is allowed, my lord, in every case, this type of project, my lord, people will misappropriate money, keep it money. If they are caught, okay, no, there was a mistake, I'm giving a revised bill and challan and all that, please close the case.
Again, you see, it could have been a very well concerted effort to twist the facts, manipulate the situation, but even then, there must be some legal basis to proceed.
My lord.
Either by the IO or the court.
So, my lord, by humble submission, the learned trial court, your lordships also observed, should have gone further rather than accepting those documents on their face value, my lord, and discharging the accused persons. If there was a certain additional material, further investigation could have been directed, my lord. But to clearly discharge all of them, my lord, in one shot, that in my humble submission is...
Yes, I think that's valid.
On suspicion documents, I'll place 1 or 2 decisions, my lord.
Yeah, please. So, you are for?
I'm for 4 and 5.
4 and 5. Who's for 1? 1 and 2. We start with 1 and 2. Why? So we'll do it on Monday then.
Monday.
Your Lordship will start with them.
We'll start with. Let us go serially. Yeah, so it might be.
No, then second problem. Monday only we'll do it. Who is out of station? Then your Lordship may hear my part. After 18. Today's what day? So your Lordship, on 15 we can do on Monday.
Why? 15? It's good. Yeah?
Yes.
Oh.
They will be adopting my submission.
We'll take it up on 22nd.
22nd.
You'll be here.
Yeah, I'll be here. Yes, I could have concluded because I think what they said they are going to adopt my submission only. They will be adopting whatever I submit.
Because you see, as what has been,
yes.
I mean, from what has been submitted, it appears that there's a case of one of the accused number 1, 2, and 3 being made out separately, and 4 and 5 separately.
Yes.
You're for 4 and 5.
Yes.
So 4 and 5, they have subsequently come. That aspect has to be also considered. When they are the only 2 persons who have come before this court, and an order has been passed, and subsequently.
No, my lord, if I'm not mistaken, after the order was passed by this honorable court, actually the last petition that we filed before this honorable court was a petition under 482 for quashing the FIR and the charge sheet. After hearing that petition at length for 4 days, your lordship, then this honorable court, on being satisfied, directed the trial court that we should be allowed, directed the trial court to look into the matter, and to allow us to file all those documents which we filed before the honorable High Court in that revision for challenging the FIR and the charge sheet, and directed us to file all those documents before the trial court, and also directed the court to take into consideration the documents filed by the defense at the time of hearing before framing of charge. Other 3 accused did not avail that opportunity of hearing before framing of charge. And the law is also there. CRPC provides under 227, if the court is satisfied why the provision has been made, if there is no sufficient material to proceed for trial against an accused, and if the court is satisfied, then court can always discharge the accused even at the before framing of charge.
That is always there.
Yes, and that opportunity, that chance was availed by us because we had sufficient material which was seized by not only that letter which was filed, that consolidated utilization certificate which was filed by us before framing of charge sheet, but NEC did not forward it to. That is, we are not to be blamed. We are not concerned about that. So far as we are concerned, we were asked to give. We have submitted the consolidated utilization certificate and audited statement.
That was before
the charge sheet. 22nd July we filed it. 30th July charge sheet was. Now
12/11/2020, I pointed out the date. This is reflected everywhere, madam.
Subsequent to filing of charge sheet, that was subsequently NEC has forwarded. NEC kept it with them. How can the accused be responsible for that? We do not have access to NEC's office when they will file. We have submitted to NEC. Our whole case is that whether a charge sheet, whether we could withdraw, we could not withdraw, whether law permits or not, those are not challenged. The rule has to be, financial rule has to be challenged. Those are not under challenge. CBI at no point of time for all these long years, they have not initiated any steps challenging the financial guidelines of the government of India, all that. But the fact is, yes, now what my learned friend is submitting before that, whether it could be permitted or not. Rightly or wrongly, it is a matter of record that we withdrew the initial utilization certificate, and why it had to be withdrawn, that also I will explain. That on the date with something which has withdrawn means what? It is not in existence. And the withdrawal letter was also seized by CBI. CBI knew that this utilization certificate has been withdrawn, means it has become an invalid document to act upon in any manner.
Who has withdrawn and which court has given permission
Obviously,
for withdrawal?
we have submitted, we have
Yes.
withdrawn. Please do not interrupt like this when I'm submitting. A document which stands withdrawn, and they knew in that letter that we are going to submit, NEC's correspondence is also there to directing us to submit utilization certificate, consolidated utilization certificate. What was the hurry on the part of CBI to file the charge sheet? Why couldn't they wait? Why did they file the charge sheet on the basis of incomplete document, knowing fully well that these utilization certificate have been withdrawn and not in existence? How can they file the charge sheet on the basis of that? They could have waited for the consolidated utilization certificate, which will be placed in place of that. They could not wait. What was the hurry to file the charge sheet, Your Honor? So our whole case was that the FIR on the face of it. Now, entire case, if Your Lordship see, when I argue, I will draw Your Lordship's attention to that. The allegations which have been brought, the sections which have been given under the FIR, that is totally different, and the finding in the FIR is different. In the charge sheet, it is only for misappropriation, but there is no such offence framed under for misappropriation. What is the correct section for misappropriation? FIR is not under that, charge sheet is not under that. But the finding in the charge sheet is there has been misappropriation of 1 crore something. Have you framed the charge for misappropriation? There is no charge framed for misappropriation. How can such a casually filed charge sheet stand in the eye of law, Your Lordship? Even the allegations which were leveled in the FIR, each and every allegation, vague allegations, all are vague allegations. One by one, all these allegations I will reply, Your Lordship. And the court was satisfied. There is no case made out. Why would even the detailed statement of expenses with all the original vouchers were submitted to CBI by us, not to NEC, along with NEC also to CBI, where details of Muse account, each and every penny spent under the scheme, each and every penny spent, we had the supporting voucher. Everything was filed and submitted to CBI. Why CBI did not forward those documents to the court? And what the Honorable High Court granted us permission is, yes, when we filed these documents before the Honorable High Court, this Honorable High Court was satisfied, and that is why directed that these documents should be placed before the trial court at the time of framing of charge. And if trial court is satisfied that there is sufficient material on record which can be relied upon, then accused can be discharged.
The records are here.
Yes, trial court records. Then even Your Lordship, we have submitted 3 big volumes of our work which was carried out. It was submitted.
What would be required is for this court to produce the process of investigation.
All those are.
You have the report has been filed.
Yes.
So there, the process of investigation would be evident. How it has proceeded, whether as has been submitted. Of course, that.
And what my learned colleague was submitting, that 6th May they withdraw just before. How do we know when CBI is going to file the FIR? Even before preliminary, Your Lordship, when preliminary investigation going on, it was not there was no order from any court, there was no direction from CBI, you cannot go ahead, carry on with the process. The project was going on that time also. So it was an ongoing project. CBI never told us that because we are doing preliminary investigation, you cannot go ahead with the work. Project was going on, things were installed, those computers, IT officers were installed in different schools in the villages, they were all using, and it is not only pertaining to the state of Meghalaya. This project was pertaining to the state of Assam, state of Arunachal Pradesh. Everywhere the project is going on. It was earlier also it was going on. Not that we started the project with the money from NEC.
So this court will hear you then.
My Lord, we'll take it 22nd as the date. We'll finish on 22nd. Yes, my Lord, we'll make it. On that date. Obliged.
Heard Dr. N. Muzika, narrated DSGI for the petitioner, CBI. The respondent would submit that the response to the submission of the petitioner, CBI, would be may be heard on the next date. Accordingly, as agreed to by the parties, this is matter on 22nd. We'll keep this matter. Come on, we'll keep this matter as the last item in the hearing list. If it could not be concluded within the last period, we'll proceed to the. We'll take it up in the second half.
We'll conclude on that.
Okay, then this is the lower court's record also should be brought to the courtroom. It is already here, Mela. We have flagged it. So my written submission is referring to the flags in the lower court's record as A, B, C, D. We have also filed an affidavit as per directions of this court, giving the flags which contains which part. So that should be brought to the courtroom.
Yes.
Obliged.
I think it's already here. Records are already here.
Well.
Okay. Lower court's record?
Most probably. I don't know whether it's been called for or not.
I don't know because they're a huge bundle. I don't know whether I don't see.
Huh? Oh, that's you don't?
Yes.
Oh.
Because I'll be referring to the lower court's record. Greatly obliged.
Daily list, item number 7.
Lordship, the senior counsel was informed by counsel for respondent number 2 that they'll be taking some time.
Who's respondent 2?
Mr. Pinongri. For respondent number 4, Lordship.
Nobody has made any mention.
Your Lordship, Mr. Pinongri is having some technical issue. He's unable to appear through VC.
On pre-made with parties, list is met after 2 weeks.
Item number 15.
Well, at item number 15, here I appear for the corporation. The matter appeared last on 5th of June. So, my lord, there was a direction that parties can sit and decide about the remaining amount. So, my lord, what happened here, I have informed my office. So we were on the impression that since the counsel were present both in the court, we will inform our respective parties. But it seems that they were expecting an official information from our side, a letter or something to call upon a meeting. So perhaps there's a miscommunication. We were waiting, they did not come. So there was apparently they expected an official letter from us, which we did not issue because we were on the impression that councils have informed their respective parties. So, my lord, a meeting.
But even then, you see, there must be some form of communication.
My lord,
to decide on a date.
That didn't happen, my lord, because as I said on my honest submission, my lord, we expected we will inform our parties. So, due to which, my lord, the meeting couldn't be conducted. So I'm praying, like, my lord, for the interest of both the parties, another date may be given. This matter can be deferred until then, my lord. So, my lord, this time we'll give them an official communication what will be the suitable day for the parties can sit together. So, my lord, that is my humble submission for the day, my lord.
Arguably, direct counsel for the respondent 3 to 4.
3 to 4, my lord.
Has submitted that
for 1 to
3 to 6.
My lord.
Has submitted that due to miscommunication. The parties could not agree on a date to sit together and to sort out the differences amongst them. It is prayed that some time may be allowed, some more time may be allowed in this regard. As prayed for. In view of the observation made by this court, by its order dated 5/6/2024, parties are called upon to make a serious endeavor to settle the matter amicably, and the related report to be filed before this court. Accordingly, that is adjourned for the day. List is same after 3 weeks.
I'm highly obliged, lordship. duty.